Good afternoon, everybody. I am Parashal Patel, a barrister at 39 Essex Chambers, and along with my colleague Steve Broach, we're going to present to you this afternoon a webinar, Prioritising Access to Life-Saving Treatment, Legal Considerations. We're hoping to run this for about an hour and a half. You'll hear first from me, as I said, then from Steve. There is a question and answer facility available on this Zoom webinar. And so after we've both spoken, we may well pick up as many questions as we can if you want to drop us some questions. There are four topics that we're going to discuss under sort of four specific headings. They are firstly, the legal basis for prioritisation. Secondly, policies which NHS bodies are adopting. Thirdly, discrimination issues arising under the Equalities Act of 2010. And then lastly, human rights considerations. The context, of course, to our discussion this afternoon is the concerning but very realistic scenario that the NHS, as we know, has limited intensive care capacity, ventilators and clinicians who can provide care and treatment to those in needs. And although there's been strenuous efforts being made to increase capacity, I think we're all quite realistic that the resources will remain finite, however successful those efforts are. And as the pandemic increases demands upon the NHS, it's inevitable that there'll be tension between what the clinicians want to offer and want to continue to offer and what they can and should offer. And in those circumstances, two questions arise. First, is it lawful for clinicians to prioritise access to life-sustaining treatment? That's the first question. And secondly, on what basis can and should the clinicians make those decisions? Section 3 of the NHS Act, this is prioritisation and the legal basis. Section 3 of the NHS Act of 2006, following the 2012 Act amendments, imposes a duty upon CCGs to provide services to such extent as it considers necessary to meet all reasonable requirements. And that is in relation to such other services, in this regard, such other services and facilities for the care of persons suffering from illness as it considers are appropriate as part of the health service, and then little f, such other services and facilities as are required for the treatment of illness. Now, that duty is in the context of the Secretary of State's comprehensive duty under Section 1 to continue the promotion in England and Wales of a comprehensive health service. What does that duty mean on the clinical commissioning groups? Well, under a previous iteration of the duty, which was on the Secretary of State, in the case of the Crown, the Secretary of State for Social Services ex parte Hinks, it was held by the Court of Appeal and by the Master of Rolls, Lord Denning, that the duty was not absolute, but in fact, the words "to such extent as considered necessary to meet all reasonable requirements" should have the words added "such as can be provided within the resources available." So that case made it very clear all the way back in 1980 that the duty upon the NHS body here is resource dependent and wasn't an absolute duty. The more recent example of that is the Crown and the Secretary of State for Health ex parte BA, the citation there on the slide. The context there was that the claimant challenged the Secretary of State's direction to the National Health Service Blood Transplant Organisation, which was a special health authority, and that direction provided for allocation of organ transplants to be prioritised for essentially persons lawfully in the United Kingdom, as opposed to priority over persons not lawfully in the United Kingdom. The claimant was somebody who was not lawfully in the United Kingdom, and he challenged this direction and said it wasn't within the Secretary of State's power in order to make that direction. By the end of the hearing in the Court of Appeal, the question was, did the Secretary of State have power to make a direction which prioritised treatment for particular persons and or group of people? The Court of Appeal emphatically answered that question as a yes. What it said was that the Secretary of State's paragraph 62, Secretary of State was entitled to exercise judgment as to which was necessary to meet the reasonable requirements at any particular moment in time, and if necessary by prioritising. The ambit of the Secretary of State's judgment was a wide one. And at 67, the scarcity of the resources that the Secretary of State had, or in fact the availability of the resources the Secretary of State had, was a legitimate consideration in deciding how to exercise his or her judgment. So in other words, what the Court of Appeal said was that the availability or lack of availability of resources was relevant in determining prioritisation of treatment in the context of a systematic NHS-wide decision. Therefore, one extrapolates from that decision a national framework or policy which pursues prioritisation of access to life-sustaining treatment in the COVID-19 scenario is within the Secretary of State's power. So as an NHS-wide policy, that would be something that the Secretary of State has power, or in fact now it would be NHS England and CCGs acting on behalf of the Secretary of State, but they would certainly have power to do that following the BA case. The question then, when it comes to individual clinicians making individual decisions, the question doesn't remain and stop there. What then happens is how can one translate that general power to the more immediate and more individual circumstance of clinicians having to make life-sustaining treatment decisions based upon resources? We should start off, I think, first with some fairly uncontroversial propositions, because in this context, what one is talking about, certainly in coming weeks and months potentially, is the availability of ventilators, artificial ventilation. So here are some uncontroversial propositions. The first is artificial ventilation is medical treatment. Secondly, withholding or withdrawing the ventilator is characterised as an omission by the clinician, so it's not a positive act. And therefore, withholding or withdrawing that treatment is not unlawful unless there is a duty to provide it. Those propositions all came from Bland, and they are probably all well known to you, and have been moved on in subsequent cases, but those are the core propositions. And then lastly, again, another proposition coming from Bland is that there's no duty to provide that treatment if it's futile or if it's in the patient's best interests. So far so good. What though would happen if the position is that the treatment isn't futile, or if it cannot be said that it's not in the best interests of the patient not to provide it? So in other words, where the treatment is adjudged to be of overall benefit to the patient, can it be lawfully withheld or withdrawn? And this must be either because it's not available, all the ventilators are being occupied, and there simply aren't any other ventilators available, or because someone else is adjudged to derive greater benefit from it. In those circumstances, one has to look at whether the prioritised decision has to be made. Now, that's not a best interest decision, because these are decisions that affect and have to affect people who are capacitous and people who, as well as people who lack capacity. So the continuation of the benefit in treatment cannot be determinative, but one gets to these very difficult questions then about on what basis can and should that decision be taken, and what happens if there's no policy or guidance to follow. How then does one take that decision? The clinician's duty of care, of course, remains with the patient. Can it be said to be discharged in circumstances where he has to exercise another duty to another patient? It would be doubtful in my submission whether that would in fact be correct. The other difficult legal issue in these circumstances is where withholding and withdrawing amounts to accelerating the patient's death. And that as a consequence of the prioritisation decision. Is there a risk of an unlawful killing? And the clinicians involved will of course want to know that. In those circumstances, is there intent? Now, there isn't a direct answer that we have in the case law, but if one looks at another case, which is the conjoined twins case, and the reference there is on the screen, that again was a different context, and it was one which involved two twins, M and J. M could not stay alive without artificial means. J would die if she remained attached to M. The question was whether the doctors could lawfully detach M from J in the knowledge that that would hasten M's death. And therefore, in those circumstances, if the doctors were to carry out the surgery which detached J from M, hastening M's death, did they have the necessary intent for thereby unlawfully killing M? The Court of Appeal, there are a number of different aspects to this decision, but the one that we need to consider at this present moment, it was divided between Lord Justice Brooke and Lord Justice Robert Walker. What Lord Justice Brooke said was it wasn't an unlawful killing because the doctors could rely upon the doctrine of necessity. And that had the three purposes there that set out that the act, the surgery, was needed to avoid the inevitable and irreparable evil. No more than should be done than is reasonably necessary for the purpose to be achieved. And that was just simply that the surgery had to be done, and that the evil inflicted must not be disproportionate to the evil avoided. Lord Justice Brooke answered those three questions in the positive and therefore found that there was necessity and therefore it didn't amount to an unlawful killing. Slightly different basis was explained by Lord Justice Robert Walker. He said the purpose of the act was to preserve the life of J and not to cause the death of M. Therefore, he said, it was inappropriate to characterise foresight of M's accelerated death as amounting to criminal intent. And he then said, well, if one had to give a meaning to the word intentionally, so intentional, you give it then ordinary or natural meaning, and therefore you only apply that to cases where the purpose of the prohibited action was to cause death. Now, of course, that then could be used in the context of COVID-19, where if one is having to switch ventilators, reallocate ventilators, the purpose of that act would be to preserve the life of the patient that's been judged objectively to have a greater chance of survival, not to cause or to hasten or to accelerate the death of the person from whom the ventilator has been taken. But this is a very difficult examination, very difficult to say that the very extreme facts of the conjoined twins case should be used more widely, and especially more widely in the context of the COVID-19 reallocation and prioritisation of access to ventilators. We then That then brings us to what guidance has been issued. This is the second of the 4 topics that I said that we were going to consider. And what guidance has been issued to help the clinicians in these very difficult decisions. The starting point is the long-standing guidance from the General Medical Council, treatment and care towards the end of life, good practice in decision making. As you know, that's guidance that we've had since July of 2010. Now, it was obviously not guidance that was issued in relation to a pandemic and in the context of a pandemic. But what it did say in relation to resource constraints is this. It said, if resource constraints are a factor, you must make sure that decisions about prioritising patients are fair and based on clinical need and the patient's capacity to benefit, and not simply on grounds of age, race, social status, or other factors that may introduce discriminatory factors into the care. You should not withdraw or decide not to start treatment if doing so would be a significant risk for the patient and the only justification is resource constraints. So back in 2010, the GMC's guidance certainly wasn't, well, you can't withdraw or withhold treatment if the only justification is that you haven't got that treatment isn't available by reason of resource. Well, unsurprisingly, the GMC has updated its guidance since, and under the section prioritising access to treatment, it states that, in fact, these doctors will have to make very difficult decisions about how to allocate resources. It doesn't say how to do so. In fact, what it says is that we advise those people who have to make these decisions to take account of current local and national policies that set out agreed criteria for access to treatment. The difficulty here, as I will demonstrate in a moment, given the rest of the guidance that we have seen, is that there is a real paucity of local and national policies and certainly no agreed criteria for access to treatment in response to the pandemic. You'll see here on this slide, there are, I've set out the sort of guidance that we have got. By far the most comprehensive of these five documents is the policy guidance in the British Medical Association COVID-19 Ethical Issues, a guidance note. And that guidance note does expressly tackle the issue of prioritisation. It in fact posits that professionals may be obliged to withdraw treatment from some patients to enable the treatment of other patients with a higher survival probability. The obligation is not set out in the guidance. It also says that doctors may involve, or there may be situations which involve withdrawing treatment from an individual who is stable or improving, but whose objective assessment indicates a worse prognosis than another patient who requires the same resource. Now, for that proposition, the BMA rely upon the Secretary of State and BA case, which we discussed earlier, and they say that it's both lawful and ethical for a doctor following appropriate prioritisation policies to refuse someone potentially life-saving treatment where someone else has a higher priority for the available treatment. Now, I've touched upon earlier whether the conclusions of the Court of Appeal can be so extrapolated. It seems to me that they can't, because what the Court of Appeal was saying in BA was that the Secretary of State or the NHS England or CCGs, there could be a national framework, a national policy for how these decisions can be made, and they have power to pursue such a policy and to set out such a policy because of the terms of Section 3 of the 2006 Act. But that doesn't mean that without more, that individual clinicians are then making especially in the absence of such a policy, which there isn't at the moment, that individual clinicians are making lawful decisions and are able to pursue prioritisation of one patient over another, given the duty of care that that clinician owes to the patient from whom the treatment is being withdrawn. These are all incredibly difficult questions. There is no right answer, but what is crying out for an analysis and some sort of framework is a national framework. So there needs to be one so that there can be a proper debate about these issues, and so that doctors are not left in the invidious situation in which they are having to deal with these situations on an ad hoc individual basis. That then leads me to the last slide that I've got, certainly, and I've as I said, whatever else can be said in relation to this topic, there is a need for a national framework and a national policy. What I've set out here are some tentative thoughts in terms of ethical and legal considerations. The first is that such a framework ought to have clearly identified aims. Now, whether those are aims based upon some sort of highest chance of survival, or whether in fact included within those aims ought to be an aim of there being the shortest duration of, say, intensive care stay or ventilator use, or whether there needs to be a combination of it. The framework needs aims and they need to be clearly identified. Criteria need to be defined, although in the context of a pandemic where those criteria need to be flexible because they need to be dynamic, they need to adapt to the situation because demands upon the resource will be dynamic and these situations will need to be reviewed very regularly. Thirdly, the process for decision making. There needs to be set out in the framework what would be an acceptable process. That process has to be reasonable. These are decisions that are being taken potentially, which are going to mean that people's lives are potentially going to be shortened. They have to be inclusive, so you have to include those people, include their relatives, ensure that their voice is heard, and they have to have a process for accountability for individual decisions. That may include review bodies working out as quickly as they can. It'd be unrealistic to suggest that they could do it in real time, but as quickly as they can to work out whether decisions that are being taken with a particular disproportion towards any particular group or in any particular way. And then lastly, a suggestion in relation to treatment being offered on a time-limited basis. In the context that we have, that is a context where there'll be an overwhelming demand on intensive care resource, it may be that treatment should be, and it certainly could be ethically suggested, that treatment would be withdrawn if that patient's prognosis worsens, after which, so it can be said that if that patient had been in that state on admission and it had been known at that time that they wouldn't be put into ICU or that they wouldn't be put onto a ventilator and therefore wouldn't have been offered that particular treatment. And so if you've got a time-limited basis for that particular treatment, you can ensure that patients, relatives, clinicians have a set period of time, a particular basis upon which to work when deciding reallocation decisions. Now, those are just some thoughts. There are some thoughts in relation to the legal basis for prioritisation. Steve is now going to deal with equality issues and human rights issues which arise and which could potentially arise if we did have a framework, and which potentially arise in relation to decisions.
Thanks very much, Parashil. That was an extremely helpful overview, in my view, of the legal basis for prioritisation and some of the concern that arises from the absence of a national framework currently. And I'd suggest that that's both a surprising and extremely unwelcome feature of the current landscape, that there isn't at the moment a national framework under which these incredibly sensitive and difficult decisions are going to have to be taken. So I'm going to look in that context at two linked issues of, hopefully you'll be able to see my screen, yes, of discrimination and human rights. Because the essence of prioritisation of treatment is, of course, discrimination, in that clinicians or responsible bodies are going to have to choose a process by which these scarce resources are allocated, and that involves discriminating between different people. But what they must avoid, of course, is unlawful discrimination. And part of the problem with discrimination law is that it's very technical. And it's very easy for someone to say and to assert, you can't do that because it's discriminatory. But that doesn't necessarily mean that the treatment will be unlawful under either the Equality Act 2010 or Article 14 of the European Convention on Human Rights. And that's why we need to look in some detail at the statutory provisions under the Equality Act 2010, which may not be desperately familiar to some people on this call, of course, because we're used to a situation where NHS resources are allocated on a general basis, and where it's very difficult to assert an individual right to treatment. But we're not used to a situation where we anticipate that critically important treatment, life-sustaining treatment, will not be available for everyone who needs it. And we are in uncharted territory, therefore. And so the role that the Equality Act in particular has to play is something we're going to need to take a very careful account of. So in terms of the headlines from the Equality Act, there are 4 different kinds of prohibited conduct that we'll need to consider: direct discrimination, indirect discrimination, and then 2 that are disability specific. And I am going to focus my talk on the protected characteristic of disability, because for obvious reasons, disabled people are particularly concerned at the idea that there will be prioritisation of treatment, because they fear that they will end up at the back of the queue. So we need to look at discrimination arising from disability, and the prohibition on failing to make reasonable adjustments, which is itself a form of discrimination. And there is, of course, then a human right to non-discrimination in Article 14 of the European Convention, as long as we're within the scope or ambit of another right, and generally that will be Article 8, the right to respect for private life and family life. We'll look at that a little later, and the possible reach of the other international law principles that may have something to say about the outcome of any human rights challenge in this context. So if we think first of all under the 2010 Act about the gateway and why it is that those involved in the provision of health services must not discriminate, Section 29, subsection 1 of the Act says that service providers must not discriminate against people requiring the service, first of all, by not providing the service. And equally, service providers must not, in providing a service, discriminate against someone as to the terms on which the service is provided, by terminating the provision of the service, or by subjecting that person to any other detriment. So you can see that the full range of possible discrimination by a service provider is covered. To the extent to which a body that we're concerned with here isn't providing a service, they'll be caught by the public functions provision in Section 29, subsection 6. So if someone is exercising a public function that is not the provision of a service to the public or a section of the public, they themselves must not discriminate against a person who is affected by that function. A duty to make reasonable adjustments applies to both service providers and those exercising public functions. And then we move on to look at the protected characteristic that we're going to focus on for today's talk. So one of the characteristics is disability, as defined in Section 6. And the key point here is that the definition is very broad. So a person has a disability if they have a physical or mental impairment, which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And the guidance from the Equality and Human Rights Commission says in bold that it will be very rare that there should be a dispute about whether a person is disabled or not. There will, of course, be occasions where that comes up, but very often it will be clear. And that's particularly the case if they happen to have one of the diagnoses that are specified at the bottom of the slide. So if someone has cancer, HIV, or multiple sclerosis, then they are automatically a disabled person for that purpose. And there's no need for the cause of the impairment to be known or understood. As long as it's accepted the person has a physical or mental impairment, there doesn't need to be a specific diagnosis. So if we move then on to the 4 types of prohibited conduct and think about how a policy or a practice in terms of prioritization of treatment in this context might offend against one of these. The first and most blatant form of prohibited conduct is direct discrimination, where someone discriminates against another person because of a protected characteristic. So here, disability. So if because of a disability, a person is treated less favorably. Importantly, of course, more favorable treatment of disabled people is not prohibited. See section 13, subsection 3. And from the EHRC Services Code of Practice, which I read again this morning, so you all don't have to. No, I would commend it to people because it's very important in terms of understanding how these provisions are supposed to work. One of the points to emphasize is that the characteristic that we're concerned with, so here disability, does need to be a cause of the less favorable treatment, but not the only or even the main cause. So there must be a causal connection between having, in this case, a disability, an impairment that amounts to a disability, and the less favorable treatment. And it is necessary to look at why the service provider treated the service user less favorably. So hopefully, cases of direct discrimination will be fairly rare because it won't be the fact that someone is disabled that is causing them to be treated less favorably. What we may see more of are issues in terms of discrimination arising from disability, which we'll come on to in just a moment. It's important to note, though, that direct discrimination can be unconscious and or based on stereotypes and assumptions about people with protected characteristics. And so that kind of unwitting direct discrimination is perhaps rather more likely. And there does have to be a comparator for a claim of direct discrimination. The issues around comparators bedevil equality law. And one of the important points is there has to be no material difference in the circumstances of the person, save that they don't have to be identical. So there may often be a dispute about whether an appropriate comparator has in fact been identified, and the code gives some more help on that. So if we think about discrimination arising from disability, the second type of prohibited conduct, a person discriminates against a disabled person if they treat them unfavorably because of something arising in consequence of their disability. And unlike direct discrimination, discrimination arising from disability can be justified. So at that point, the burden then shifts to A, the person who's alleged to be discriminating, and they have to show that the treatment is a proportionate means of achieving a legitimate aim. And there must be a degree of knowledge, so the duty does not apply, or the breach would not arise, if they can show that they didn't know and could not reasonably have been expected to know that the person had a disability, or the disability. So in terms of how that might operate, if we go back to the language of section 15, subsection 1, if a person is treated unfavorably because of something arising in consequence of their disability, so for example, their health, their physical health, an assessed degree of frailty, then that prima facie establishes the breach in section 15(1)(a), subject to justification. And so the person alleged to be doing the discriminating would have to show that what they're doing is proportionate and is targeting a legitimate aim. We'll come back to both those concepts when we look at indirect discrimination shortly. So indirect discrimination under section 19 of the Act is probably going to be where much of the attention focuses. Because in essence, before we look at the technical wording, indirect discrimination is where you have a general policy or procedure which applies to everyone or to a broad class of people, which disproportionately adversely affects a particular group in a way that can't be justified. And so, for example, having a policy that says that those with a particular degree of frailty will always not be treated, whatever it might be, has the potential to result in indirect discrimination because it's a blanket application but will disproportionately adversely affect disabled people. And we see, if we look at the technical language, that indirect discrimination happens where a provision, criterion, or practice which is discriminatory in relation to a disability is applied. And then we get the definition of what that means. There's a 4-stage test, which is well known to any discrimination lawyer. So first of all, the policy, the provision, criterion, or practice has to apply generally. So it's got to apply to, in this case, disabled people and non-disabled people, like a prioritisation policy in terms of access to health services, then it has to put the category, so people who share the protected characteristic, which can be a particular impairment, doesn't have to be all disabled people, at a particular disadvantage when compared with people who don't have that characteristic. So there has to be a class-based disadvantage. And then at C, there has to be that disadvantage manifesting itself for the individual, the particular disabled person here. And as long as you have those three steps, then again, the burden shifts to the alleged discriminator, who must show that what they're doing is a proportionate means of achieving a legitimate aim. If we look at the services code on these issues, it tells us to consider this test in two stages. First of all, when thinking about legitimate aim, is the aim of the policy, the PCP, the provision, criterion, or practice, is that aim legal and non-discriminatory, and one that represents a real objective consideration? Well, I would imagine in most of the situations we're talking about today, the answer to that will be yes. There will be a real objective consideration that there is an insufficient supply of ventilators or other resources, and the aim will be to allocate those available resources fairly. So we're almost certainly going to get through, or the relevant health body that's being challenged would get through that first limb of having a legitimate aim, one would hope. If they do get through that limb, then the next question is the means of achieving it proportionate? And the way the code describes proportionate is that it's appropriate and necessary in all the circumstances. Now that may well be sufficient as a headline, but of course we know that proportionality is a rather more sophisticated concept than that. It is often approached in 4 stages itself. And in particular, the question that's asked is at the end of the analysis is whether it strikes a fair balance between the rights of the individual who's concerned and any wider public interest that can be identified. And that notion of a fair balance is inherent to any kind of proportionality review. We see more on legitimate aim in the code, that the aim should not be discriminatory in itself. That's quite important, I'd suggest, because the aim must be the fair allocation of resources across the population, I'd suggest, because otherwise there is a risk that any aim would itself inherently be discriminatory. And we're told that ensuring that services and benefits are targeted at those who most need them and the fair exercise of powers can both be legitimate aims. Important to note as well the link between types of discrimination. So the code tells us that if there's been a failure to comply with the reasonable adjustment duty, it will be very difficult to then defend a claim of indirect discrimination. And unsurprisingly, the more serious the disadvantage caused by what's said to be a discriminatory PCP policy, the more convincing the objective justification must be. Now, in the kind of scenarios we're concerned with, it's hard to imagine anything that could be more serious than the loss of life, and therefore there must be the most convincing kind of objective justification to defeat a claim of indirect discrimination. Now, this is what the BMA say about the potential for indirect discrimination in prioritisation of health resources. They say that although a capacity to benefit quickly test, which is their suggested test, would be indirect discrimination, well, not quite. It would get through the first 3 stages of indirect discrimination. In our view, it would be lawful in the circumstances of a serious pandemic because it would amount to a proportionate means of achieving a legitimate aim under Section 19(1). Namely fulfilling the requirement to use limited NHS resources to their best effect. To which I say, well, yes, it would certainly, on that description, seem to be a policy in pursuit of a legitimate aim, but that doesn't necessarily answer the proportionality question, because we need to know more about how the capacity to benefit quickly test was to be applied. You need to know, for example, what does benefit mean? Are there any assumptions built into that test as to the quality of life the person must have in order to be said to be benefiting from the treatment? How quickly do they need to benefit from it? Is there a requirement to make a reasonable adjustment to acknowledge that some disabled people may take longer to benefit from that kind of intervention? Those are all the questions that you'd need to ask before being able to assert, in my view, that a policy based on a capacity to benefit quickly test would necessarily be lawful under the Equality Act. And it's important, I'd suggest, pointed out by others recently, that the BMA note doesn't address the reasonable adjustments duty in the 2010 Act. And so the reasonable adjustments duty in particular here is to focus on scenarios where policies put disabled people at a substantial disadvantage in relation to relevant matters in comparison with non-disabled people. And where there is that substantial disadvantage present, then there's a requirement to take such steps as it's reasonable to have to take to avoid the disadvantage. And that certainly needs to be considered. Now, it may be that on these facts, there is no step that could reasonably be taken to avoid the disadvantage, but that's not good enough to merely assert. That would have to be considered and reviewed. And also importantly, there's a requirement to provide accessible information under the reasonable adjustments duty. One of the concerns that I've seen and heard many disabled people raise is simply not knowing what's going on at the moment, where guidance is issued incredibly quickly, it's then withdrawn, amended, reissued. It may not be clear what precisely has changed. Different people subject to the guidance may be acting on different versions of it. And none of that, in my view, is consistent with a requirement to provide accessible information as Section 20, subsection 6, specifically mandates as a reasonable adjustment. Schedule 2 of paragraph 2 goes into more detail as to how the reasonable adjustments approach works in the service provision context. And it says that being placed at a substantial disadvantage, which you'll recall as part of the test, means if a benefit is going to be conferred, being placed at a substantial disadvantage in relation to the conferment of that benefit, i.e. getting life-sustaining treatment, for example. But also if the person is going to be subject to a detriment and suffering an unreasonably adverse experience when being subjected to that detriment. And it may be said that withdrawal of treatment in this context should be looked at as a detriment rather than the conferment of a benefit. So there may be a slightly different approach depending on whether the question is whether someone should start getting life-sustaining treatment or whether they should have it withdrawn in the scenarios that Parashar was saying may very unfortunately occur. And a few exceptions from the reasonable adjustments duty, which we probably don't need to dwell on for reasons of time. The slides will of course be available after this webinar. My favourite paragraph of the code, I do have a favourite paragraph of the code, is paragraph 7.4, saying that the policy of the Equality Act is not a minimalist policy of simply ensuring that some access is available to disabled people. It is, so far as is reasonably practicable, to approximate the access enjoyed by disabled people to that enjoyed by the rest of the public. The purpose of the duty is to make reasonable adjustments, the purpose of the duty to make reasonable adjustments is to provide access to a service as close as it is reasonably possible to get to the standard normally offered to the public at large. This is the social model of disability writ large. This is saying it's the job of society as a whole to remove the barriers that disabled people face to access to services, including critically important services that might sustain their life. And what we should be aiming for as a society is the same, or at least as close as we can get to the same standard that everyone else enjoys. When you're considering whether or not there is a reasonable adjustment to be made, the factors that the code says should be taken into account include whether taking particular steps would be effective in overcoming the substantial disadvantage that disabled people face, the extent to which it's practicable. Of course, we're thinking about a scenario with the worst kind of resource constraints, financial and other costs, and the extent of any disruption which taking the steps would cause. And so the countervailing factors, wider public interests, can be taken into account. Finally, on the Equality Act, but certainly not least, very important to keep in mind section 149, which is the public sector equality duty, the PSED. And again, the code, the services code, makes clear that non-compliance with the PSED may well set up a successful claim for a breach of one of the substantive discrimination provisions as well. So the PSED requires all public bodies to have due regard to a series of specified needs when they're carrying out their functions, which would of course include any functions around prioritisation. And the needs that are specified that have to be kept in mind include the need to eliminate discrimination and the need to advance equality of opportunity. So not just the negative need, if you like, of making sure or aiming to ensure that unlawful discrimination is eliminated, but also a positive need to promote equality of opportunity for here disabled people. And the high point of the case law on the PSED, certainly in the disability context, is Bracking, which is the successful challenge to the first decision to close the Independent Living Fund. And from the Court of Appeal's decision in Bracking, it's clear there are really two key issues for public bodies to keep in mind when they're trying to show compliance with the PSED. First of all, have they properly understood what the impact of the decision is going to be on disabled adults, disabled children, whoever are the affected group. And part of that is facing up, frankly, to difficult decisions, including the sorts of decisions that may have to be here, and acknowledging and accepting the consequences of the kinds of prioritisation we're talking about. And we should keep in mind that prioritisation in access to social welfare services is nothing new. It's a built-in feature of almost all the social welfare schemes, certainly anything to do with social care. It's just fortunate that until now we haven't had to consider these issues in the context of life-sustaining treatment. But the principles, I would suggest, remain the same in terms of fairness and non-discrimination, and acknowledging and being transparent and open about what the impact is likely to be on the particular group. And then there has to be, the second point from Bracking, specific regard by way of conscious approach, the case law says, to the specified needs. So it's not enough to just have generalized consideration of equality issues. You have to specifically think about the need to eliminate discrimination, the need to advance equality of opportunity, and consider what's being proposed in the light of that. Now, it's also clear that the PSCD has an implied duty to engage with disabled people in this instance and others affected by decisions in order to discharge what's described as the tame side duty of reasonable inquiry. And so if the public body doesn't have enough information to properly have due regard to these needs, they may well be required to consult to the extent required to get that information so that they can discharge the PSCD. And one of the very worrying features, I'd suggest, about the crisis so far has been the number of occasions where public bodies have brought out guidance very quickly, have been challenged on it, particularly in the disability context, and have then had to withdraw and amend that guidance, which, whereas in fact, if they just engaged briefly with the constituency that were affected at the outset, that may have all been avoided. So although there is clearly a massive rush, there's also a need to do things properly. And I'd encourage public bodies to consult and engage with disabled people to the greatest possible extent in the circumstances that they find themselves in. So that's the whistle-stop tour of the provisions of the Equality Act that I think are of particular relevance. I'm now going to move on to look at some of the key human rights considerations, and must give great credit and thanks to my colleagues Gethin and Ruth for their work to help prepare this part of the talk. So again, I'm conscious that there are people on the webinar with very varied degrees of understanding and expertise around human rights. So just to go back to the basics, we are of course primarily concerned with the European Convention on Human Rights, the ECHR, which was incorporated into English law through the Human Rights Act 1998. And that's what Section 6 of the Human Rights Act does. It says that public authorities must act in accordance with the convention rights that are scheduled to the Act. But we're also concerned, in the disability context, greatly concerned with the UN Convention on the Rights of Persons with Disabilities, the CRPD. Now, the CRPD is not yet incorporated into English law, but it is clearly relevant in at least three ways. And I get those here, sorry, skip a slide. From the benefit cap case, the first of the benefit cap cases that went to the Supreme Court, SG and the Secretary of State for Work and Pensions. And it was clear from that judgment that the CRPD and the other international conventions can and should inform decisions on whether ECHR rights have been infringed. So for example, in Matheson and the Secretary of State, which was the case about disabled children losing their benefits when they've been in hospital too long, it was held that the breach of Article 14 in that case was informed by the failure to have regard to the children's best interests, which is required under both the CRPD and the Children's Convention. So first of all, and probably most importantly for our purposes, the CRPD is relevant to whether or not there's been a breach of an ECHR right. The CRPD can also help resolve any ambiguity in domestic legislation. There may be some on analysis, and it can help inform the development of the common law, which is also potentially going to be very important, because some of the common law rights, for example, around fairness and transparency in decision-making may well be in play in these kinds of cases as well. But just to go back to what we would expect to be the relevant ECHR rights, most obviously, of course, Article 2, the right to life. There's also a risk of a breach of Article 3, the absolute right to be free from torture and inhuman and degrading treatment, the bar there, of course, being set very high. But where there was likely to be the most controversy, I'd suggest, is around Article 8, which is the composite right to respect for private and family life and the home and correspondence. And the private life limb in particular of Article 8 has been held to encompass considerations of human dignity, considerations of autonomy, considerations of respect for people's physical and psychological integrity. So it's a broad scope, Article 8, but the right is relatively weak because interferences with people's private lives can be justified in the way that Article 8.2 provides for, which we'll come back to. So 2, 3, and 8 are probably the most relevant substantive convention rights. And then we have Article 14, which provides there should be no discrimination in the enjoyment of the other convention rights. So it's not a freestanding prohibition on discrimination, it's a prohibition on discrimination in the enjoyment of people's other human rights. So what about the CRPD? Well, I went back to the CRPD this morning in preparation for the talk, and these seem to me to be some of the key rights in that document. And I would suggest that even if we are not accepting that there's anything binding about the CRPD, which I would suggest is itself a dangerous assumption, it sets a standard, an international norm for respect for disabled people's rights, which everyone involved in these kinds of decisions, I suggest, ought to be striving to comply with. So I would hope at the very least the CRPD is being used as an audit tool to check that any policies or procedures are rights respecting for disabled people. First of all, we have Article 5, the general provisions in relation to equality and non-discrimination. Article 10 is the specific right to life for disabled people, which has to, perhaps sadly, specify that the right should be enjoyed on an equal basis with others. So there's a built-in equality provision within the right to life in Article 10. Article 11 deals specifically with situations of risk. And I think certainly on at least one analysis, that would cover the kinds of scenarios we're talking about here during the pandemic and the need for disabled people's interests to be prioritised and their rights respected in those kinds of emergency situations. Article 17, describing disabled people's rights to physical and mental integrity. And then perhaps most relevantly, Article 25, which is the right to the enjoyment of the highest attainable standard of health without discrimination. And that language of the highest attainable standard of health, I think, is really important because, again, it shows the goal to which we should be striving is to support disabled people to enjoy the best possible health, not simply a minimalist policy, which we may see, unfortunately, in practice. Participation rights are fundamental. And Article 8, although it may not be breached in any particular case in substance, reasons we'll see in a moment, does imply a right to be heard on decisions that impact on people's private life, their family, their home. And so the case law shows that procedural entitlement under Article 8 is to be heard and involved in decisions to the extent necessary to protect your interests. And it's the nothing about us without us principle that people should not be merely the objects of decisions that are taken that impact on their physical and psychological integrity, for example. Those participation rights are then fleshed out in the Children's Convention and the Disability Convention as well. So certainly for disabled people, there is an enhanced right for them to be participating in decisions that affect them. Just want to move on to some of the cases now, which do show the limits of the human rights principles in the healthcare context. And perhaps to start with the case of Conliffe, which is probably the most relevant of the cases, although it's now relatively old, and does concern quite a different context. So the issue in Conliffe was Mr. Conliffe seeking exceptional funding for gastric surgery to deal with his obesity. And one of the arguments that was put forward on his behalf was that the narrow focus in the exceptionality policy on clinical issues breached Article 8 because there was a requirement to look at wider social and welfare considerations. And that claim failed in the Court of Appeal, with a very clear finding that Article 8 doesn't give rise to a positive duty on health services to consider non-clinical social or welfare considerations. And so the relevant considerations are the comparative medical conditions and medical needs of different patients when deciding on the allocation of funding for medical treatment. And it might be said that actually that approach rather protects disabled people from stereotypical and negative assumptions about social or welfare considerations, which might see them being put further down the queue than non-disabled people. But the problem with Conliffe is that it does go further than simply saying, well, there's no duty to look outside social or welfare, outside clinical factors, and suggests that there is in fact no interference with any Article 8 right when the decisions are taken about the prioritisation of health care. But context is everything. And I suggest that a decision to withhold or withdraw treatment in an ICU may engage Article 8 in a way that the decision in Conliffe was held not to. I don't think personally that Conliffe is a complete answer to any kind of Article 8 claim in this context. I should have said at the beginning of this talk, of course, we are not giving advice today, and these are incredibly difficult issues and will need very sensitive fact-specific advice in any particular case. I thought earlier that the European Court's judgment in MacDonald in the UK might have some relevance to these kinds of difficult issues, although it arises in the social care context rather than the health context. A very famous case in the disability community, Elaine MacDonald challenging the decision of the Royal Borough of Kensington and Chelsea to withdraw her overnight care and replace that service with incontinence pads, even though she was not incontinent, but simply needed assistance to use the commode. And a claim was brought all the way up to the House of Lords, and that failed. Supreme Court, sorry, just the Supreme Court. And there was held to be no breach of Article 8 in that case. And in the domestic courts, it was looked at very much as to whether there was a positive obligation under Article 8 to provide the care, and the answer was definitively no. But in Strasbourg, interestingly, the European Court took a different approach and considered whether the withdrawal of care amounted to an interference for the purposes of Article 8.1, which says there shall be no interference with a person's rights, etc., and held that it did. And so distinguished the cases where people have been looking for a positive obligation to provide care services and haven't found one, and said in this case, that the fact that the care was being taken away amounted to an interference. And they went on to hold that there was in fact a breach of Article 8, but only for a limited period where there had been no reassessment, which was required at the time under the domestic law. So the interference wasn't in accordance with the law. Now that's the theme I'm going to come back to here. So what I would suggest in light of MacDonald in the UK is that there's at least a possibility that the withdrawal of life-sustaining treatment for resource reasons, in the way that Parish or Positive might happen, could be an interference with a person's Article 8 rights, which would therefore fall to be justified under Article 8.2, and otherwise it would be unlawful. Of course, it's worth keeping in mind that that would involve the court following MacDonald in the UK rather than the Supreme Court, which may not be immediately likely, but it may be something that the Supreme Court itself would have to be asked to consider again. Important to note a few other remarks, at least, or aspects of the case law. And this is from Burke, another notorious case, where the Court of Appeal held that the conclusion of the judge at first instance, which they upheld, the broad conclusions, didn't lead to a further conclusion, that if a national health doctor were deliberately to bring about the death of a competent patient by withdrawing life-prolonging treatment contrary to that patient's wishes, Article 2 would not be infringed. There's a double negative in there. The clearer sentence is what follows. It seems to us that such conduct would plainly violate Article 2. Now, I suggest that that should be giving doctors and those advising them quite a significant pause for thought. A clear statement by the Court of Appeal that deliberately to bring about the death of a competent patient by withdrawing life-prolonging treatment would plainly violate the right to life. But of course, context is everything, and Burke was not decided in the context of a global pandemic and a huge disparity between the level of need and the available resources. So I don't suggest that that broad statement is necessarily immediately applicable to the current position, but there's certainly a risk that it would be. And I'd suggest that some very careful thought would need to be given about withdrawal of life-prolonging treatment and how much weight the term deliberately can bear in that sentence. About what Parish was saying about what was the intention of the act. Was it to bring about the death of one patient, or perhaps was it instead to preserve and protect the life of another? Then we get to Article 14. Now, Article 14 as the non-discrimination human right clearly encompasses both direct and indirect discrimination. In order for there to be an issue under Article 14, we have to be within the ambit of a substantive right. And so there's a big question immediately about whether Conliffe precludes an Article 14 claim based on Article 8. My view is that it doesn't, and that it's still possible to assert, even in the light of Conliffe, that these kinds of issues are within the ambit of Article 8, even if there's not a substantive breach. In order for there to be a claim under Article 14, there has to be a recognised status. Disability is a recognised status, but so will be a whole range of other issues, including those that are not protected characteristics under the Equality Act. And then if there is differential treatment or a differential impact in an indirect discrimination sense, or if there's a failure to treat differently because there's a broad reasonable adjustments kind of duty under Article 14, which was identified by Strasbourg Court in the case of Thlimanos, the state then has to justify that. And the bar, I would suggest, for justification here is very likely to be set low because of the run of cases that say that in socioeconomic decision making, the test is whether that differential treatment or the differential impact or the failure to treat differently is manifestly without reasonable foundation. And so it will only be necessary for the alleged discriminator to show a reasonable foundation for that differential treatment, etc., in order to avoid a claim under Article 14. But in some cases, of course, there may not be such a foundation, and the case law shows that careful inquiry will be needed. And this point I wanted to emphasize is entirely to the credit of Gethin and Ruth. I wasn't going to look at the EU Charter, but I'm very glad that they brought it to my attention. Article 35, saying that everyone has the right of access to preventative healthcare and the right to benefit from medical treatment, etc. A high level of human health protection should be ensured. And the EU Fundamental Rights Agency has suggested that the prioritisation of tackling the spread of COVID-19 puts this right at risk. And so there may be an issue under the EU Charter in relation to potential breach of Article 35 if there is not a proper process by which these decisions are made fairly. Just before we end, perhaps I'll do it in the context of the McDonald's slide. When we're thinking about Article 8 issues, it's very easy to get drawn straight into considerations of proportionality, which is how Article 8.2 ends up. And it will be necessary in any case where there's an interference with someone's Article 8 rights for a proportionality review to be conducted. But before we reach proportionality, there's a requirement that the interference is in accordance with the law. And part of that test is that the law is sufficiently accessible and foreseeable and clear so that people who are affected can understand what their rights are. And if we go back to Parashil's talk and think about that slide that had that long list of hyperlinks to different guidance documents, none of which are themselves comprehensive, many of which cross-refer to each other, and several of which, it might be said, duck the issue as to how prioritisation is supposed to happen, or perhaps are not actually intended to address that question. I think there's a real issue about whether or not the framework that these decisions are taken under is in accordance with the law. So if the decision does interfere with a person's Article 8 rights, it seems to me there's a real question about whether there is automatically then a breach of Article 8 because there's no sufficiently accessible and foreseeable legal framework. And I'd anticipate that that might be one of the first issues that arises. And the person, of course, the legal person with responsibility for that must be the Secretary of State, because ultimately it must be the Secretary of State's responsibility to ensure that the framework for treatment prioritisation decisions is sufficiently accessible and clear and foreseeable, that those decisions are in accordance with the law. So that's the end of what I was going to say about the equality and human rights considerations. I think the intention now is that we're all going to look at some of the questions that have come in. So I'll hand back to Parashil. If I can give up my sharing of my screen. There we go. Parashil, are you coming back on to deal with questions? If not, I'll just start plowing away on the ones for me. See if there's any questions that are coming for me. One that's come in is about the difference between guidance and law. Well, one of the aspects of the case law on the in accordance with the law requirement under Article 8 is that the law doesn't have to be limited to statute or even to case law in common law countries. It can include guidance documents, it can include policy frameworks, as long as they themselves are sufficiently robust and clear to amount to a legal framework in practical terms. And what I would suggest at the moment is that we just don't have that. The kind of plethora of guidance documents that have come out from different official bodies doesn't amount to a legal framework that is in accordance with the law. Ms. Parashil.
Hi, sorry everybody. I technologically challenged there for a bit. One thing I would like to mention is that whilst we were on the webinar, NICE have produced some new guidance, clinical guide for the management of critical care for adults with COVID-19 during the pandemic. And I mean, it's a brief document. I've had a look at it very quickly. It recognises the extraordinary burden on critical care. It recognises that they have had surge capacity in the NHS as a consequence of that extraordinary burden. But what it doesn't do, and it's very disappointing, is it doesn't contemplate that the need to prioritise access to critical care where demand outstrips supplies. It's completely silent on that. It almost seems to suggest that the surge in capacity that is being delivered by extra hospitals, extra clinicians, more ventilators is going to mean that we won't need to reallocate ventilators or ICU beds. And so all it does say is in the context of the surge capacity, there should be a daily review such that the goals of ICU are met and outcomes in relation to that particular patient are realistic. So we're still waiting, I'm afraid, for some guidance from, other than from the BMA, about what to do where demand outstrips supply.
That's very interesting, Parashil. I think that's a record for guidance being issued on the topic of a webinar during the webinar. At the moment, it feels like that kind of thing's happening to us all the time. Can I pick up a question that came in that's very closely linked to that? Because in the absence of a national framework, a question that's put is whether relying on clinical expertise and having a professional making the decision on the basis of their individual clinical judgment is sufficient to meet the in accordance with the law requirement. I'm very interested in what Parashil thinks about that. My view is no. I don't think that that is the kind of decision-making process that Strasbourg has in mind when it talks about the law being accessible and foreseeable. Parashil, do you have a view on whether...
Yeah, I agree, because that would then focus the entire decision on a clinical basis, whereas the decision has more than a clinical basis about it in order to be lawful. One very important factor that it has to be is consultation with the patient and relatives, and a process of doing so in order that they can understand what the limits of these decisions are and when these decisions are going to be taken in advance, so that you go into ICU or you get put on a ventilator and you know what the limits of that treatment is likely to be at that time, or at least you have some sort of reasonable foreseeable knowledge about it. So no, I would think that that's definitely not enough. Plus, the other thing it does is it leads potentially, if there are no fault of the clinicians, to inconsistent decisions.
Exactly. And that's where discrimination risks really arise, yeah, isn't it? Because you have, if you're just told, well, it's up to clinical judgment, that really begs the question, doesn't it? Because who's exercising that judgment and how are they exercising it is entirely individually sensitive. We've got another related question, which I think is very important, which is in essence, what do we do about it? Because if we're right that there are these risks in relation to potentially discriminatory or unlawful treatment, how can anyone challenge it? And I think that's a really difficult question, and obviously fundamentally important to stop this just being an entirely academic discussion. And it really does involve advocates, local groups, specialist lawyers being accessible and available, so that if there are concerns arising, extremely quick challenges can be brought, because we are going to be dealing with, by definition, emergency cases. Also, of course, if public bodies are transparent and publish their policies and their procedures, that does at least permit the potential for a challenge to be brought in advance, which would be much better for all concerned, I'd suggest. But if there isn't a clear published policy for a particular trust or a particular service, then it may be that those challenges can only be brought at the point that decisions are being made, and that's going to be extremely difficult.
Yeah, and I think, Steve, one other way of dealing with that, which is, this is a very good question and a very important part of the analysis. How are decisions to be challenged, or how are they to be reviewed, given that they're going to be taking place, or if demand outstrips supply, it will be taking place in very speedy circumstances. And I think one thing that was being considered by a lot of trusts is review bodies, and review bodies with particular expertise involved in, independent expertise. So you'd have disability rights organisations having members on those boards to work out, not in real time, but in some sort of time, whether these policies, whether these decisions were being taken with a view to there being discrimination or not. And it might be that would have to be the way in which one would deal with it, given the way in which these decisions would be taken.
Particularly if those boards and bodies could involve disabled people and representative organisations, and that was a point you made earlier, Parashar, that I thought was really important, is the need for proper engagement with the community rather than imposing these review processes from the top down, perhaps.
Yeah, and I think what's really disappointing thus far, and I'm sorry to keep going on about how disappointing it is that we're almost acting as if this is not a realistic outcome, where we're going to have to make these priority decisions. And we have the time, because at the moment everyone who needs ICU and who needs a ventilator is getting one, fortunately, and who can benefit from it is getting it. But there may well come a realistic scenario, we hope not, but I think it's realistic that it's going to happen, where we're going to make these priority decisions. And we've got to work these decisions out, these issues out in advance, because there just simply isn't going to be enough time to do it in real time.
Absolutely. We've got a question about, a very interesting question, a difficult question about patients with cancer, correctly pointing out that a patient with cancer is a disabled person. And so for that reason, I suggest amongst others, we can't have blanket policies about them as a group. But what's said is that we can often estimate prognosis in these patients. And can we use that expectation of prognosis as a basis for ITU prioritisation? To which my immediate answer is yes, potentially. So clearly prognosis is a relevant factor. If we're thinking about capacity to benefit, or capacity to benefit quickly, that takes account of all the circumstances of the patient. But it must be slightly more nuanced than that, I would suggest, because what is meant here by prognosis? Prognosis of what? Prognosis of merely of surviving, prognosis of attaining a standard of living, which I think it's the BMA guidance that helpfully says would be acceptable to the person and is subjectively beneficial, as opposed to based on some kind of objective norm. So I would suggest that's a starting point, but it shouldn't be an end point on its own for prioritisation decisions. But Parashar, do you have a view on that?
I think you're right in terms of it having to be a subjective decision, because that is the norm. So if we weren't in a pandemic, that would be the norm for admission to ICU and the norm for this treatment in times where you wouldn't need prioritisation. So why should it be any different in those circumstances? So I would agree that in those circumstances with that at that point.
A political VIP is entitled to greater, swifter access to ICU beds than other members of the public.
Say that again.
Are political VIPs entitled to greater or swifter access to IBU?
Well, I think the point there is there some sort of social utilitarian priority? And because we've only really been discussing in this webinar about clinical utility and what clinical benefits there are, which would include greatest chance of survival, but it would also include shortest stay in terms of ICU, freeing up a bed, and the combination of the two. But when do you start getting into more social utilitarian points? I mean, do you do that? I think that's incredibly difficult. Because where do you stop? Where do you start? I know you have to draw a line at wherever you stop and start, but it doesn't quite feel right, to be honest.
I agree, and I think the even harder question that's in the same vein is healthcare workers. Can we prioritise healthcare workers on the utilitarian basis that they'll then get better and help keep the rest of us well? I don't really want to try and answer that now, other than to say you entirely see where that's coming from, but where do you then stop? And in order to give a positive answer to that question, you must be capable of drawing the line in a way that doesn't result in unlawful discrimination or a breach of a person's human rights.
We've just had a question in, Steve, which is who carries out the decision as to who is a less priority? And also, will the families be informed as to how these decisions were reached? And I think the point there is that that's what one would expect by way of a framework or a policy as to how the priority would be worked out. Now, of course, one could and can in individual cases, just obviate from that particular framework, but one would expect there to be a framework, a policy as to how policies are to be, how priorities, I beg your pardon, are to be assessed, and then who should be making those decisions, and they should be the doctors or clinicians who are then doing it in accordance with those policies. So that is how I think that it ought to operate.
Agree entirely. Parashar, there's been a number of questions on the feed, but also in advance about consultation and involvement of advocates and others. And it seems to me that the broad answer to those questions is, to the greatest possible extent, the person obviously should be consulted and involved in the decisions that are going to be affecting them. But so should IMCAs, for example, independent mental capacity advocates, family members, other advocates, concerned people, all taking into account the crisis context that's likely to be arising. And there was, interestingly, again, just before we came on, I think, some new guidance about hospital visiting, relaxing the restrictions on hospital visiting, where a person would be in distress, were they not to be visited by, for example, a family member. So there seems to be an increasing trend. What seems to have happened is that the guidance documents have come out in a very blanket way, very strict way, perhaps for understandable reasons. And then when issues are flagged up, they're then loosened or made more flexible or made subject to a reasonable adjustment to recognise the particular circumstances of disabled people. And what would be great is if we could avoid having to do that in these critical life and death policy situations, and actually have policies from the outset that are building in the reasonable adjustment, rather than us having to come along retrospectively and try and fix things. So yes, in short, in order to avoid an unlawful discrimination, people are going to have to be involved in the decisions.
Yeah, and I think one of the things I said in terms of the framework, which it needs to set out a process for these decisions. So you can't, I don't think, set out criteria or fixed criteria for prioritisation, but you can set out a process. And the process has to be inclusive, and it has to be a reasonable one. So what would you expect in the circumstances? And that would and may well include IMCAs advocates if people lack capacity, although one has to remember that these aren't best interest decisions. Best interest decisions will hopefully have happened prior to this, i.e. is it in this person's best interest to continue to receive the intensive or critical care that their condition requires in order to keep them alive. And if the best interest decision is yes, well then you need to go on further because of a lack of resources, a lack of availability of resources, to say, are these the people then who are going to be prioritised for this treatment? So there's two stages there.
Yeah, I completely agree with Parashar. Sorry, that the thing I agree most with about the BMA's guidance is that it's not a best interest decision, it's a public law decision. That just has to be right, doesn't it? Because we're in a context of resource constraints.
Yeah.
And that's difficult for people because people are used to thinking about serious medical treatment decisions as best interest decisions, but we're in a different territory here, and that has to be recognised. Can I just flag another very interesting question that perhaps puts us both on the spot, Parashar, which is we've both said, I think, in the talk, that we think there needs to be a national framework. And the question is, well, why? Why does it have to be national? Because where local prioritisation frameworks have been challenged, they've normally been successfully defended. And could you not just have a similar approach where each trust produces their own policy framework, and that's good enough to comply both with the statutory and common law requirements and the human rights requirements?
Steve, I think my answer to that is that in the circumstances, in the context of the pandemic, it may be that you're right, that it would be enough, or it could be enough. It certainly could be argued to be enough. But my real difficulty with local policies and why a national framework is better is because there is then the potential and a greater risk for inconsistency. And depending upon the extent of the inconsistency, there's then the scope for challenge. But I wasn't in the least saying the reason why I favoured a national framework was because of consistency and all the other benefits it brings. I wasn't saying that we shouldn't have any local policies. In fact, doctors and clinicians, they need some guidance, they need some framework, and any framework almost is better than none.
I'd agree with that, certainly the last point. I'd go a little further, I think, in terms of discrimination and human rights considerations. The idea that each local area would have its own framework for decisions that are as important and as sensitive as this. They certainly have to be very clearly publicised, very clearly available to those concerned in order to be, for example, in accordance with the law. And surely, what I don't understand, put it another way, is why would you have a proliferation of local frameworks? Certainly in terms of the headline question of how are we going to prioritise treatment in this crisis? Isn't that quintessentially a national decision? Because it's about answering a very profound set of ethical questions, which I don't think the answer to that should vary locally. How you implement that policy, of course, that's a matter for local judgment. But the headlines seem to me to be something that the national bodies should be taking responsibility for.
Yeah, I think I agree. We just don't seem to be there, and
we haven't got anything at the moment.
We don't seem to be getting anything. So when you're looking at this matter and you've got a clinician who's got no idea what to do because there's no guidance on it, I'm sure they would benefit from a local policy rather than none at all.
Absolutely. If I was advising a trust, I'd be saying do two things. First of all, challenge the Secretary of State and ask where's my guidance, and secondly, make my own up in the meantime, because clearly having your own local framework has got to be better than having no framework at all for these decisions.
Yeah, absolutely.
Can we just take an age discrimination question, Shil? Someone saying, is there a risk of age discrimination in prioritisation? And obviously the answer to that has to be absolutely yes. And one of the things I think we can all agree on, and the BMA certainly say, is some kind of blanket rule that said we're not treating over 65s or over 75s would be extremely hard to justify on an age discrimination analysis. That would be direct age discrimination, which, even if capable of justification, would be given very strict scrutiny by the courts. So
yeah, I think it would almost be impossible, actually,
yeah,
but that would be lawful. Funnily enough, the Italian guidance that they issued did have an upper age limit of 75, I think. They recommended it. But I don't know to what extent their discrimination laws are similar to ours. But I think I would have no doubt in saying if you had just a simple, straightforward age cutoff, that would be unlawful discrimination.
I completely agree.
Yeah.
Great to see lots of questions are still coming in. We obviously do our best. We haven't got long left, have we? But we can see if we can answer perhaps
10 minutes. No, 5 minutes. Right. So
I've got one. How do you challenge a blanket policy of non-visitation? Well, as soon as the phrase blanket policy is used, discrimination lawyers' ears prick up, of course, because that's the basis of an indirect discrimination claim. And I've had a lot of very distressing conversations in the last couple of weeks with people who are being told they can't visit under any circumstances with no consideration of the individual situation. Now, obviously, there is a very compelling imperative to prevent the spread of the virus, but other factors need to be taken into account as well. And so I'd suggest blanket policies can be challenged under both the Equality Act as a form of indirect discrimination and in the disability context for failure to make reasonable adjustments, but also under human rights provisions, particularly Article 8, because it will be a significant interference with the person's family life as well as their private life. And so it will have to be proportionate. And again, in accordance with a published policy and in accordance with the law.
Yes. Steve, there's two questions here that I've just seen. The first one is that a prior issue, which is that before people even get to hospital, they're being kind of discouraged or being turned away. Care homes saying that they shouldn't take residents to hospital. Now, again, of course, that as a blanket decision, not an individual decision for a particular person, is discriminatory, unlawful, it seems to me, and therefore you can't have such a blanket policy that you don't allow residents to go to hospital, you keep them in the care home. I don't know what you think about that.
completely agree, and it's very concerning, isn't it? I've seen again lots of reports of this. I think it was over last weekend in particular, where whole groups of care home residents were being told you won't be taken to hospital, or were being encouraged not to go to hospital because what's the point? You won't get treated, and that so obviously runs contrary to people's human rights and their basic human dignity as well, which is the foundational stone for all human rights considerations. You can then articulate its unlawfulness in lots of different ways, but it's just offensive, and it needs to be strongly challenged. And it has been, importantly, there has been a big pushback, including correspondence from NHS England and others saying we cannot take these kind of blanket approaches.
Yeah, and then the next question, I wonder what you said in response to, I think, our discussion about social utilitarian approach. We got a question here saying, wouldn't that potentially bring Article 3 into play? Is it not inhuman and degrading to make an assessment that one person is of such lesser social value than the other that they should die so that the other one might live?
I don't want to be making those decisions. I mean, that's just an absolute nightmare for clinicians, isn't it? I think the point to take account of here, something I said earlier about the Equality Act, is the technical nature of some of these provisions. And of course, human rights lawyers are very aware that Article 3 sets an extremely high threshold. And inhuman and degrading treatment, those words need to be given full force. So something that doesn't fully respect a person's human dignity might breach Article 8, but for it to breach Article 3, it's got to be really bad in terms of inhuman and degrading of their dignity and their personhood. In the care context, the case of Bernard and Enfield, where a disabled parent was left to urinate and defecate on her living room carpet and wasn't able to look after her children, didn't breach Article 3, did breach Article 8, but didn't breach Article 3. So we need to be careful not to assume an Article 3 breach unless the situation is intolerably bad, which of course it may be in some of these cases.
I think it though does make the very real point that we instinctively recoil when we're making decisions which are about the value of X person's life as opposed to Y person's life. It's just not something that as a society we feel comfortable about doing, and we ought not to be doing it unless we absolutely have to.
I completely agree, and that's why the word benefit in the BMA's test of capacity to benefit is so important, isn't it? What benefit are we looking for? Because if it's merely not to die, then that's objectively measurable. But once we go beyond just the simple fact of staying alive, value judgments have the potential to start to creep in, and discriminatory assumptions or other unhelpful and unlawful consequences. So I'd welcome more clarity about what benefit means in that context.
Steve, I think the time is up for us.
Yeah.
We've got quite a lot of questions. Now, I think that we might well try and get to those in writing if we can, and people stay on. I don't know how this works in terms of if we do we have to stay on the Zoom in order for it to work?
I fear that if we end the webinar, then we'll lose our questions as well. I certainly don't mind spending another 5 minutes trying to cover a few more. Should we try? I've got one that I'd really like to take on, actually, which is a question that I've had asked of me in a number of different ways, which is, and it's put this way, in terms of people who have cancer having treatment cancelled because everything is being focused on COVID-19. And I do think that's a fair challenge, isn't it? COVID-19 is an illness. There are other illnesses, and it may be irrational, never mind discriminatory and breaching people's human rights, to stop everything else that's going on in the health service in order to focus on the virus. And if people are having essential treatment cancelled, then that is potentially unlawful and should be challenged by specialist solicitors, because it's not obvious to me that the NHS can't do anything else other than treat the virus because of the consequences that would have for people's health more generally.
Yeah, I think, Steve, that would be a very difficult challenge, though, in the current context, because what we are being told is that the NHS's resources are stretched and are at critical limit in dealing with emergency situations, whether they're COVID-19 or not. And if we then, if you're then able to say, and very sympathetic to someone who's got a essential operation or essential treatment that is to be provided, it becomes quite difficult in the context of finite resources to argue that.
I agree. But
Yeah.
then the challenge there would have to be to the more strategic resource prioritization decisions, because you would hope that there is enough resource left over to meet absolutely critical other needs. I completely understand that all elective or even very important treatment is going to be cancelled, but something that's going to itself help someone stay alive seems to me that needs to be left behind. And
Yeah, I agree with that. I mean, and I think to some extent the guidance, certainly in the BMA guidance, says that you mustn't discriminate positively in favour of someone who has COVID-19. You've got to give them access to critical care, whatever the source, as it were, of the problem. So I think that isn't something that is encouraged. We've had another question about whether, in fact, you could bring a judicial review to parts of the BMA guidance. Certain parts of the BMA guidance. What's your putting you on the spot a bit there, Steve?
Yeah, I think you can. I think you can, can't you? I mean, certainly something I've been spending a lot of time doing is judicially reviewing or threatening to judicially review bits of guidance that have come out that are arguably discriminatory against disabled people. And it's been very successful in that the public bodies concerned have changed the guidance before we've had a need to go to court. And if people felt that something from one of the bodies, or essentially one of those documents that your links, are unlawful in some specific way, then a claim could be made against it. And there's a lot of controversy about what is the test for a guidance or document or a policy document to be unlawful. I think that the test is stated in a case called Letts, which is that it leads to, permits, or encourages people to take unlawful decisions or do unlawful acts. And so the guidance has to be focused on lawful conduct and avoid a real risk and an unacceptable risk of unlawful conduct. And with that in mind, if you keep that test in mind, you can go through guidance documents and say, well, that bit's not good enough, as was done, for example, on the NICE guideline, which said that the clinical frailty scale, the CFS, should be applied to everyone, even though it was designed for older people, and it ran the risk of younger disabled adults being assessed as being very frail because of their personal care needs, when in fact that wasn't the intention of that document at all. So that challenge was made, and the NICE quickly changed the guideline in response. It's a great example, I think, of how specific problems with guidance can be picked up, and judicial review is a very flexible process and can operate very quickly. So yes, in short, if people have real concerns about particular aspects of guidance, I think it can and should be challenged.
And I think we've got a sort of related question here about whether, in fact, once you've done guidance, or if you are about to do guidance, especially if you work for a trust, whether you should run your guidance past lawyers before you publish it. And I think, well, there we are. I was going to do exactly the same, which is I think the answer is, especially in this context, given the kind of publicity we've got and given circumstances we're in, I think if you're going to adopt guidance, you ought to get the sort of, at least a sort of seal of approval from somebody.
Completely agree. Completely agree. It's a great question that I've just instantly lost. Oh yes, how do we determine that the resource is exhausted? Because it's a national health service, and so the specific example that's given is to healthcare providers who exhaust ventilator capacity in London need to look at transfer to another city if there was capacity, for example, in Birmingham. I mean, my immediate reaction to that is yes, they do, with a human rights lens, particularly. I mean, the extent to which there's the positive obligation under Article 2 to preserve life is a really interesting question, and there's some suggestion that the Strasbourg case law is perhaps more generous on that than the domestic case law has been. But again, just in terms of rationality, if there's ventilator capacity somewhere and your patient can get to it, that must be explored, I would have thought. Would you agree, Parashar?
Absolutely, it must be explored before you would then take some sort of priority decision, whether it's common law, rationality, or whether it's actually pursuant to your obligations under Article 2. I think you've got to do that. What I had understood was, in fact, that there has been a lot of sort of ventilators moving around the country, or there is said to be that suggestion of ventilators moving around the country, so that there may well be local surges which can then be dealt with by excess capacity elsewhere. Obviously, what we're talking about is where there's no capacity at all, even if you were to reasonably go around the country looking for it.
that's the hardest edge of this, isn't it? And it's,
Yeah.
as you say, Parashar, it's not, unfortunately, it's not an unrealistic prospect in the relatively near future, and that's the
No,
context.
no, absolutely.
We need to get their heads out of the sand, frankly, and there needs to be an answer. No one's suggesting the answer is easy, but there has to be one, doesn't there? Whether it's local or national. So everyone who's on this webinar who's able to influence that locally or nationally, we think there needs to be some urgent work done. Okay, is there anything else that we think is pressing that we need to address?
I can't see anything else in the queue off straight away. Let's have a quick look.
Yeah, we'll have a quick scroll. Obviously, with apologies, there's lots and lots of individual questions. We've tried to group them and address themes that have come in. And if we've missed anybody, apologies. Can I just take one that is important, I think, which is the difference between positively prioritising patients and negatively discriminating against them. And it's very much two sides of the same coin, isn't it? It's the conjoined twins example of are you doing something that brings about death, or are you doing something that promotes life? The Equality Act, of course, focuses on the consequences for the individual. So for the disabled person here, are they being discriminated against because others are being prioritised? And it's only in relation to the protected characteristic of disability that you're expressly allowed to treat that person more favourably. Otherwise, treating one group more favourably is very likely to result in unlawful discrimination against the other group. So that is certainly the way in which a discrimination lawyer would frame it, and the court would look at a discrimination challenge if one was brought. Questions in about the Mental Capacity Act and deprivation of liberty safeguards. Again, the speed at which things are moving at the moment, we were sent around, I think, 20 minutes before the webinar started, the new guidance that's come out on the operation of the deprivation of liberty safeguards in the current context, published by the Department for Health and Social Care. The thing I saw immediately was, unsurprisingly, people being encouraged to take a proportionate approach and to prioritise the most urgent cases. But the take-home point on the law is that the Coronavirus Act doesn't affect the operation of the Mental Capacity Act or the DOLS scheme in England. So anything that was required to be done in February is still required to be done. And of course, what the crisis has done is almost certainly put back the introduction of the liberty protection safeguards even further. So it's still the DOLS, they are still the scheme. And if you can't come within the DOLS scheme, but then many people, of course, won't outside the hospital and care home context, they won't. It will have to be an application to the Court of Protection. Of course, that's going to have its own resource constraints. So it's not a very happy situation there either. I haven't had a chance to read the new guidance properly. And no doubt it will give more of a steer as to how responsible authorities respond.
Yeah, and I think in particular in terms of ICU and deprivation of liberty, we've obviously still got Ferreira in the Court of Appeal, which says there's no need for those DOLS organisations to be made. So one doesn't need to be wasting one's time doing that in ICU.
Very good policy sense, if nothing else, doesn't it? There's a helpful contribution about guidance from the Faculty of Intensive Care Medicine and the Intensive Care Society, stressing the need for clinicians to keep notes and to write down their rationale for decisions that are made. And I think for all parties, that's going to be extremely important, isn't it? Both for disabled people, family members and others who want to understand decisions, and for clinicians and health bodies that may need to justify themselves. So now more than ever, again, another burden, of course, but it's going to be really important to properly record why decisions are taken and against which guidance or against which framework, given the lack of a national applicable guidance document.
Yeah.
Have we covered everything?
I think we probably have, actually, Steve. I'm just looking.
So yeah, really grateful again for Ruth and Gethin's assistance with this talk all the way through. They've been monitoring the questions for us and supporting us to work out what we need to answer. And
I think we're being instructed by Ruth and Gethin, Steve, that we probably have covered everything as far as
we're done. Excellent.
Yeah. Thank you, everybody. Yeah. Speak soon.
Yeah. Thanks very much for everyone's attention and good luck.
Yeah. Bye.
Bye-bye.